Now, compared to the US, we have a problem with fault. In the good old days, if you substantiated fault, a wife would be entitled to alimony indefinitely. If she was responsible for the dissolution, she may lose her right to alimony. Fault used to be litigated everywhere in the US to impact the financial rights of the parties. Now, we've taken a position in many of the jurisdictions is that we know that divorce is very emotional, it's a nightmare, it's the worst that people are involved in, although ultimately it boils down to dollars and cents. Let's try to pull out the fault. Let's try to minimize the acrimony so people don't litigate indefinitely and fight about who's at fault of the dissolution. So many states adopted no-fault divorces. And in the states that, New Jersey, for example, we have an irreconcilable differences statute. California has irreconcilable differences. Many have ceasing sexual relations for 12 successive months. That would be sufficient to dissolve the marital relationship. New York does not have a no-fault. The most progressive state supposedly doesn't have a no-fault. When I litigate cases, I'm a practicing attorney. I litigate both in New York and New Jersey. When I litigate a New York case, the cause of action is very important. And depending on what side I am, I use it as leverage. Because that's how you'll be able to settle cases. You have to look out for the best interests of your client. So you must substantiate and have a trial on the cause of action in divorce in New York to be able to dissolve the marital relationship and then talk about your financial rights. It's a very, very backward system where the majority of the states still have no fault. And in the states that have no fault, like New Jersey, there's been an attempt by certain individuals that are litigating. If the husband, let's just give you an example. Husband is an absolute nightmare. And he makes a lot of money, but he loves those expensive cigars and he loves to gamble. So, every week he's in AC and every other weekend he's in Las Vegas and he's dumping hundreds of thousands of dollars every week in gambling. Now, the wife goes and petitions for a divorce. Why shouldn't the fault for this dissolution be considered in the allocation of the debts or in the allocation of the marital assets? So what our courts throughout the country have said is that fault, in very, very rare circumstances, will come into play in the apportionment of the financial rights. But it has to be an extraordinary situation. So just like in Islamic law where there is this apportionment based on harm, even in our U.S. system we do have circumstances where we look at fault for purposes of the finances. But it's in very, very sparing circumstances. Now, we look at the mutual divorce in these different statutes. If you look at Egypt, in 2001, they amended their law to provide for this mutual divorce that we call khul'a. Although khul'a is provided for in the classical treatises, everywhere you read, it specifically says a khul'a divorce means a wife doesn't like her husband. He wants to be rid of this marital relationship. So she needs to go say, look, husband, I really don't like you. I want out of this relationship. So what can I do to compensate you to give me the consent? So when you go with this type of cause of action for khul'a, you need the consent of the other spouse. Well, how about the other spouse is going to be a vindictive guy and refuse to grant you that consent? You won't be able to get your divorce. Just like in a situation where you have, under a Jewish setting, that you need to draft that document and deliver it to the wife so that she's rid of the chains of matrimony, a husband in an Islamic setting may be able to say, well, I don't consent. Now, so what did the legislators do with that? They took this concept and they wanted to play with it. The Egyptians decided, well, if she files for khul'a and she waives her postponed dower and any financial rights, he has no option. He must grant her the divorce. So now it is mandated by law in Egypt. The wife files for a khul'a divorce. It's done. She waives the rights. She's free from the chains of matrimony. Jordan still takes the classical position. Article 102 through 104 still talk about the consent of the husband. That you need to obtain the consent of the husband. However, as we spoke before, they do have a cause of action for dissolution based on harm. So if the husband is vindictive and giving her a hard time, he can still maintain the wife can maintain a cause of action to dissolve the marital relationship based on harm. But what Jordan did is another interesting thing, is they said, because the husband has the unilateral right to dissolve the marital relationship at will without cause, well, sometimes this husband is using it in an arbitrary fashion. So we're going to make him pay for that. If he dissolves a marital relationship in an arbitrary fashion, we're going to call it an arbitrary divorce. An arbitrary divorce pursuant to Article 134 of the Jordanian Code, Family Code, the wife will be entitled up to 3 years of compensation in the event of a divorce, 3 years of support in the event of the dissolution of the marriage that's considered arbitrary. So the wife will have a cause of action for compensation. Morocco took a very egalitarian perspective. Very interesting. Morocco is fascinating. I'm working actually on a case now in Morocco. I do a lot of expert work throughout the country, testifying about family laws and Middle Eastern laws, and I'm working, tomorrow I'm technically supposed to be testifying in the District of Columbia, and hopefully it's going to be rescheduled, on Morocco. Because I need time to prepare. I was deposed yesterday, so I'm kind of ready. So Article 114. Parties can agree to the dissolution, and the conditions of this dissolution, whatever the terms and conditions, they got to make sure if it involves anything with custody, that it doesn't violate the best interests of the child. These are very interesting changes that you see. You cannot waive rights to custody as compensation for your obtaining the consent. The court is supposed to take into consideration, if they cannot agree on what amount the compensation is going to be, the court needs to take into consideration the amount of the dower, the duration of the marriage, the reasons why she wants out of the marriage, and the financial status of the husband. Imagine, this is almost the same standards that we use when we're doing equitable distribution or alimony. So the Moroccan legislator added all these categories. The duration of marriage is important, the reason why she's asking to be out is important, and the financial status, and the court will look at that to determine what would be a reasonable amount for consent. So, and then the court says if the wife insisted and we're unable to get this husband to agree with a number, then she's entitled to be able to petition based on cause. And by petitioning based on cause, she doesn't waive the financial rights. Kuwait takes the classical perspective. Article 111, you need the consent of the husband. The UAE, same thing. Article 111 takes the classical perspective, you need the consent of the husband, and so does Saudi Arabia. Now, in the U.S., in a no-fault divorce, you need, if you want an uncontested divorce, you need both parties to agree to the cause of action. And if they don't agree to the cause of action, then you would need to proceed based on a complaint seeking a dissolution based on grounds. The financial rights arising out of a marital relationship are a little bit complicated in Islamic law, in the sense that under the U.S., in a dissolution of marriage, what are the financial rights that arise? We take a position that all assets acquired during the marriage are considered marital assets. And if they're marital assets, then they're supposed to be apportioned between both parties. If you're a community of property, they're supposed to be equal. If you're in an equitable distribution regime, like the majority of the states, it has to be apportioned depending on 14 or 15 factors, ranging from duration, who acquired it, what you bought before the marriage, educational level, the age of the parties, and so forth and so on. Now, under Islamic law, if you look at it from a historical perspective, 7th century, it was quite revolutionary in the sense that it said, in 7th century, a woman has her independent legal capacity. She's an independent person. She can acquire property. She can sell property. She can bequeath property. She can do whatever she wants with her property. Any money that she has, the husband has no claim, equitable or legal, to her property. So this is quite revolutionary, 7th century. up until the 19th century, we still